This is a fictional story inspired by real systemic issues documented in public research on estate mismanagement and inheritance disputes. All characters, institutions, and events are entirely invented. Any resemblance to real persons or organizations is coincidental. $847,000. That is exactly what my brother called 11 years of our mother cleaning strangers' bathrooms on Saturday morning so her children would never have to. In 14 years of federal forensic work, I had learned to read a discrepancy, the way my mother read a broken promise, not with argument but with documentation. He had 47 slides. I had 47 pages of what those slides were designed to replace. Filed with the probate court at 9:47 that morning, 23 exhibits, documented with the cold precision of someone trained for 14 years to find exactly this kind of gap between what a record says and what the world contains. Thomas did not know the filing existed. He did not know about the codicil either. In the far corner of the conference room, my mother's closest friend of 41 years sat with her purse in her lap and waited. She was 79 years old. She had driven 40 minutes that morning because Eleanor had written her name into the will. She had been told, for 2.5 years, that the estate was still being processed. Nobody at that table had pulled out a chair for her. Nobody offered her water. Nobody said her name. I would like to move now to the distribution schedule, which reflects, before you do. I set it at the volume you used to ask someone to pass the salt, and every pen in that room stopped moving. Drop a comment and let me know where you are listening from, and whether you have ever sat across from someone who was lying and already had everything you needed in your pocket. 14 months earlier, Sarah Bennett sat in a folding chair at a pressed wood desk in a studio apartment in Columbus that she rented for $890 a month, eating a container of Greek yogurt at 11:23 at night because she had forgotten to eat dinner. The apartment was on the 4th floor of a building that was not quite old enough to be charming and not quite new enough to be comfortable. The overhead light flickered when the heating system kicked on. The desk had come from a Goodwill 2 blocks east and listed slightly to the left. On it was a 15-inch laptop, a legal pad covered in her own handwriting, 3 highlighters in blue, orange, and red, a cold cup of coffee she had made at 7 in the evening and forgotten about, and a manila folder labeled in her own careful block letters, Estate Initial Review. Her monthly take-home from the Federal Bureau of Financial Investigation was $5,340 after taxes and health insurance. Rent was $890. Her car payment was $312 on a 2019 model Civic she drove 23,000 miles a year for work. Lily's after-school program cost $420 a month. Add groceries, utilities, the student loans from the accounting degree she finished at 26, and the $200 a month she sent to her mother's elderly neighbor to help with a heating bill that had quietly become a crisis. And what remained each month was not financial stability. It was controlled falling, managed carefully enough that no one could see it from the outside. That evening, her phone had buzzed with a text from Aunt Patricia. Thomas says the estate is still being handled. Do not worry, honey, he knows what he is doing, he always does. Sarah read the message. She did not reply. She opened the manila folder instead. Her mother, Eleanor Ruth Bennett, had died 14 months ago on a Tuesday in February, in a hospital room that smelled of antiseptic and the carnations Sarah had brought the day before. Eleanor had been a middle school math teacher at Jefferson Preparatory in Carver Falls for 34 years. She had worked weekend house cleaning jobs for 11 of those years, arriving at strangers' homes at 7 in the morning on Saturdays in clothes she kept separate from her school wardrobe, because she was precise about what things meant and what they were for. With that work, she had saved enough to purchase a 4-unit rental property on Clement Street in 1987 for $61,000. The building had appreciated steadily. She had invested the rental income carefully, spent less than she earned in every year since, and never, in 67 years of living, thrown away a receipt. When Eleanor died, the estate Clement Street 2 savings accounts totaling $214,000, a modest stock portfolio, and the contents of a safety deposit box at First Regional Bank, passed under the management of Thomas Charles Bennett, her firstborn per a will signed in 2009. What the 2009 will did not reflect was 14 years of additional observation. What it did not reflect was a woman who had quietly watched her son manage money the way some people manage a story, smoothly, persuasively, and always slightly differently depending on who was listening. Sarah had begun to notice the seams 8 months after the funeral when she asked Thomas for a copy of the estate's annual accounting and received instead a 3-paragraph email containing the phrase, "Standard Executor, Administrative Hold. Beneficiary verification pending secondary documentation review." She read it 4 times. Then she did what she had been trained to do for 14 years. She filed a formal request for estate records through the probate court's discovery process. Thomas's attorney objected. The objection was overruled 6 weeks later by a judge who noted, without particular warmth, that beneficiaries of an estate have a legal right to its financial records. The files arrived in a compressed folder at 6:14 in the morning on a Thursday, 847 pages of transactions, invoices, correspondence, and account statements spanning 6 years. She opened them that night. By 2 in the morning, she had found the first discrepancy. A charge of $34,000 labeled Structural Maintenance, Clement Street Property, Quarter 3, Year 2. She cross-referenced it against the city's permit database, the building's maintenance log she had requested separately, and the contractor registry for Carver Falls County. No work order on file, no permit pulled. No contractor by that name registered in the county for that period. She highlighted it orange. Orange meant no corroborating document exists. By the following Saturday, she had found 11 entries highlighted orange. By the time Eleanor had been gone for 8 months, Sarah had built a spreadsheet documenting 23 irregular transactions across 6 years, drawn from the estate under expense categories that existed in Thomas's accounting software and in no auditing standard she had ever encountered in federal practice. The total was $847,000. She did not call Thomas. She did not call Aunt Patricia or Cousin Mark or Uncle Don. She called a probate attorney named Victor Crane, recommended by a federal colleague in the Cleveland field office, and emailed him the spreadsheet at 10:49 at night on a Tuesday. Color-coded. Cross-referenced. Sourced to the page number of every document in the court record, Victor's reply arrived 11 minutes later. "Sarah, this is not a bookkeeping error. Call me." The audit took 4 more months to complete. Victor engaged a second accountant, Eleanor Walsh, 22 years of forensic practice, to independently verify Sarah's methodology. Eleanor Walsh's written conclusion, delivered on a gray November morning, read as follows. "Findings are accurate, documentation is thorough and replicable. This represents the most cleanly constructed fraud case file I have reviewed in over 2 decades of practice. Sarah paid Victor's retainer out of her own savings, $6,200 spread across 3 months. She skipped Lily's spring field trip because the activity fee was $85. She could not move without moving something else. She ate a lot of beans and rice and told herself, at the listing pressed wood desk each night, that Eleanor had done harder things for longer with less certainty that it would end well. And then, 9 weeks before the scheduled will reading, Victor called her with something else. Eleanor had visited his office 9 months before she died. She had brought a document she had prepared with a different attorney, a codicil to her 2009 will. It named Sarah Louise Bennett as co-executor of the estate with override authority in cases of documented fiduciary breach. It had been signed in the presence of 2 witnesses and a notary public on a Tuesday afternoon. Eleanor had not told Thomas. She had told Sarah only once, obliquely, on a Sunday 6 weeks before she died, her voice quieter than it used to be, but still, always, precise. "The paperwork is with Victor Crane. You will know when to use it." On the morning of the will reading, at 9:47 in the morning, Victor filed 2 documents simultaneously with the Carver Falls Probate Court. The first was Sarah's forensic audit report, 47 pages, 23 exhibits, $847,000 in documented irregular withdrawals from the estate of Eleanor Ruth Bennett. The second was the codicil. Thomas did not know either document existed. Now Sarah sat at the far end of an oak conference table, watching her brother advance through a 12-slide presentation, and she understood something her mother had understood long before her. Preparation is not aggression. It is simply what you do when you already know what the numbers say and you are willing to wait for the right room to say them out loud. 3 things still had to happen before the day was over. The first was that the supplemental filing window at the probate court closed at 4:30 in the afternoon. Victor had submitted. But if Thomas's attorney filed a counter motion before that window closed, the timeline could extend, potentially 24 more months of Thomas as sole executor, 24 more months of an account losing money that had already been lost. The second was this room, this table, these people at 6 in the evening. A formal will reading attended by every member of the Bennett family and a reporter from the Carver Falls Gazette who had come to write a feature about Eleanor's legacy as a beloved teacher. Thomas had arranged the interview. He had not anticipated that the story might be different than the one he had prepared remarks for. The third was Lily's school concert, 8 in the evening, 40 minutes by highway, a promise made not to Lily but to Eleanor. In a room that smelled of antiseptic and carnations. "I will be there, Mom. I will be there for her the way you were always there for them." The numbers were simple and brutal. 6 hours and 16 minutes. 3 things. 1 day. Sarah picked up her cold coffee drink, set the cup down without a sound, and looked at her brother standing at the head of the table, still advancing slides, still speaking, still entirely certain that he was the only person in this room who knew what the estate contained. He was wrong. He had been wrong since 9:47 that morning. He just did not know it yet. Sarah was 11 years old. It was a Tuesday in October, and she was sitting on a metal folding chair in the Carver Falls County Records office while her mother stood at a long table under fluorescent lights that hummed at a frequency slightly too high to be comfortable. The records office occupied the basement of the county building on Grant Street. It smelled like dust and something faintly chemical, the particular smell of old documents stored in acid-free folders by people who understood that paper was a form of memory. The carpet was industrial gray. A water stain on the ceiling tile above the microfilm machine had spread into the rough shape of a hand, and Sarah would remember it for the rest of her life because she spent so many hours staring at it while Eleanor worked. This was the 3rd Saturday in a row they had come here. Their neighbor, Harold Finch, had sent a letter 3 weeks earlier. Typed, formal, delivered with the quiet confidence of a man who owned a business in town and had a lawyer whose name appeared on the letterhead in raised print. The letter claimed that Eleanor's garden shed, which Eleanor had built herself over a long summer weekend when Sarah was 7, measuring and leveling and painting it the same pale yellow as the kitchen, was encroaching 18 inches onto Finch's property. It demanded the structure be removed within 60 days or legal proceedings would commence. Eleanor read the letter at the kitchen table. She read it twice, slowly, in the way she read everything that mattered. Then she folded it, placed it inside a manila folder, wrote Finch Property Dispute on the tab in her precise block letters, and filed it in the hallway cabinet between insurance documents and school records. She did not call a lawyer that evening. She called the county records office. The estimate she had received from a local attorney was $400 an hour. $400 was nearly a full week of house cleaning work. Eleanor had done the math before she picked up the phone, which was why she put it down and called the records office instead. "They keep surveys on file," she told Sarah the following Saturday morning, braiding her daughter's hair before they left. "Somebody drew the line between those 2 pieces of land a long time ago. That line is still somewhere. We are going to find it." Sarah remembered her mother's hands moving through the deed filings, patient and methodical, the same hands that graded 40 homework assignments on Friday evenings without complaint. Eleanor did not know exactly what she was looking for. She knew only that if the answer existed, it would be in this room, in some form of paper, and that paper was either on her side or it was not. On the 3rd Saturday at 11:14 in the morning. Sarah remembered the time because she had been watching the clock above the microfilm machine with the focused attention of a child who has been told they are participating in something that matters. Eleanor found it. A survey, commissioned in 1967 by the original owner of both lots when the land was first divided. The document recorded property measurements in the precise, unambiguous language of surveyors who understood that clarity was a form of protection. The boundary line it described did not run where Harold Finch's letter claimed. Eleanor's shed stood on Eleanor's land, by 4 inches. Eleanor did not react with triumph. She did not close her eyes or exhale, or do any of the things that people do in movies when they find what they were looking for. She placed the survey on the photocopier, made 2 copies, paid the 25-cent fee at the front desk, and folded the copies into her purse. In the car, with Sarah beside her and the October light coming flat and amber through the windshield, she said something that Sarah would turn over in her mind for 27 years. "You do not need to be louder than them, Sarah. You do not need to be angrier, and you do not even need to be smarter. You need to be more prepared. Paper does not get nervous. Paper does not forget what it said last year in order to seem reasonable this year. Paper just waits quietly in a folder in a records room somewhere for the right person to read it out loud." Harold Finch withdrew his letter before the small claims hearing. His attorney called Eleanor's legal aid volunteer and used the phrase "mutual misunderstanding" 4 times in a single paragraph. Eleanor's attorney responded with 1 sentence. "My client accepts the withdrawal and considers the matter closed." Eleanor did not frame the survey. She returned it to the manila folder, filed it back between insurance documents and school records, and made dinner. Sarah became a forensic accountant because numbers were the closest thing she had found to that survey. They did not adjust their conclusions based on who was asking. They did not become more persuasive under pressure or more uncertain when challenged. They said the same thing to a federal judge at a formal hearing that they said to a junior analyst alone at a desk at 2 in the morning. They waited, in a spreadsheet, in an exhibit folder, in a 47-page audit report for the right room. She had built the case against Thomas's estate management the way Eleanor moved through those deed filings, not with urgency, not with anger, with the specific and unhurried discipline of someone who understood that the truth was already present in the documents. It only needed to be organized, sourced, and spoken aloud by someone with the patience to find it and the standing to say it. Eleanor had known this day would come. That was why she went to Victor Crane's office 9 months before she died. That was why she said, 6 weeks before the end, in the quieter voice she had developed by then, but which still carried its full precision. "The paperwork is with Victor. You will know when to use it." Sarah knew. She had known since 9:47 that morning. Now she sat at the far end of an oak conference table and watched her brother command a room that had not yet been told it was listening to the wrong person. Thomas recovered first. He always did. Recovery was, Sarah had come to understand, his primary professional skill, the seamless pivot back to the established narrative after a disruption, executed with enough smoothness that observers could not always identify the exact moment the pivot had occurred. "What my sister may be referring to," Thomas said, turning his address to the room rather than to Sarah directly, "is a supplemental filing that my own office has been preparing in coordination with the State Council. Any documentation submitted in connection with this estate goes through the executor's review process before becoming part of the active record. That is standard procedure." Whitmore, the estate attorney, cleared his throat carefully. "I would want to see the specific filing before commenting on its procedural status." "Of course," Thomas said, as though this were the most natural sequence of events imaginable. He picked up the presentation remote. It was 2:19 in the afternoon, 2 hours and 11 minutes until the court window closed. Across the table, Aunt Patricia leaned slightly toward Sarah, the lean of a woman who managed her own discomfort by managing the comfort of the people around her. She was 68 years old, with soft gray eyes and a cashmere cardigan the color of fog. She had, for as long as Sarah could remember, confused keeping the peace with keeping the truth. "Honey," Patricia said, barely above a whisper, "Thomas has worked so hard on all of this. Your mother trusted him with it for a reason." Sarah looked at her aunt. "I know she did," she said. She said it without coldness. Then she looked back at Thomas. Mark was examining his water glass with unusual focus. Uncle Don appeared to have become very interested in the contents of his jacket pocket. Linda was writing in her leather notebook again, her handwriting small and controlled. The room had taken on the quality of a group of people who had collectively decided to wait for something to resolve itself without requiring anything of them. Is the silence in a room like this a form of neutrality, or is it simply a more comfortable form of agreement? When everyone around a table decides that watching is easier than speaking, who, exactly, are they protecting? Thomas advanced to the fifth slide. Now, if we can move to the Clement Street property valuation. Thomas, Sarah's voice, the same measured volume. Before the valuation, I would like to formally request that this presentation be paused until we receive written confirmation from Whitmore's office that this morning's court filing has been acknowledged. That request is within my rights as a named beneficiary. I would like it noted for the record. The pause this time was longer. Whitmore looked at Thomas. Thomas looked at Whitmore. The look that passed between them was one Sarah had seen before. Not guilt exactly. The calculation of two people assessing, in real time, how much the other person in the room actually knows. "Sarah," Thomas said, and this time the patience in his voice had acquired an edge, fine as a paper cut and precisely as difficult to see. This kind of procedural disruption is not what today is supposed to be. Mom wanted this to be a moment for the family to come together. I would ask you to respect that. I would like it noted for the record, Sarah said again. Whitmore wrote something on his legal pad. Thomas set the remote down. Under the standard executor administrative hold, he said, his voice dropping into the tone of a man explaining something to someone who is choosing not to understand. Any supplemental filing submitted without the executor's review and authorization is subject to formal challenge on grounds of procedural irregularity. I want to be transparent with this family about that so no one is surprised later. That is all I am saying. Sarah opened her laptop. She did it without announcement. She placed it on the table, lifted the lid, and waited for the screen to wake. What statute, she said, not looking up, grants a primary executor the authority to challenge an independent court filing on grounds of procedural irregularity when that filing pertains to a co-executor's rights under a valid codicil? The room was very still. I am sorry, Thomas said. The specific provision, Sarah said. I want to make sure I understand the legal basis before we proceed. Whitmore had stopped writing. His pen rested against the pad. Thomas's jaw moved slightly before words came. This is not a legal seminar, Sarah. We are here to honor what Mom built. Her instructions are in the codicil, Sarah said, which is part of the court record as of 9:47 this morning. So yes, honoring her wishes is exactly what we are doing. It was 2:31 in the afternoon, 1 hour and 59 minutes until the window closed. She had said the word codicil aloud in this room for the first time. She watched it move through the air. She watched it reach Thomas. Linda's pen was still. Aunt Patricia had stopped her slow nodding. Mark was no longer looking at his water glass. He was looking at Sarah. He was looking at her the way a person looks at something they have been avoiding looking at for a long time. I am not aware, Thomas said with careful, measured control of any codicil. I know, Sarah said. She did not explain further. She returned her attention to her laptop screen. In the silence that followed, Whitmore opened a file on his own computer. Sarah could see his screen from her angle, not perfectly but clearly enough. On his desktop, behind the active window, sat a folder. It was labeled Bennett Trust Transfer Draft Revision 4. She looked at it for exactly 2 seconds. She did not change her expression. She did not write anything down. She filed it the way she filed everything, precisely, immediately, without reaction, in the part of her mind that worked the same way at federal proceedings as it did at family tables. She noted what it suggested, that a draft existed, that it was in at least a 4th revision, and that it had been prepared in Whitmore's office under a file name that did not include the words, Estate of Eleanor Bennett. She said nothing. Thomas was composing himself with the specific effort of a man who has just understood, for the first time, that he may have miscalculated something significant. She did not help him understand what, exactly, or by how much. There was a sequence to this, and the sequence was not finished. The laptop clock read 2:33 in the afternoon, 1 hour and 57 minutes. In the corner by the window, Dorothy Hayes sat with her purse in her lap, her coat with its broken button, and the expression of a woman who had been waiting 2.5 years to hear something that sounded like her name being remembered. She was still waiting. That would change. But not yet. Thomas called a recess at 2:36 in the afternoon. He did not call it that. He said, "Let us take 10 minutes while I make a brief call to clarify some procedural matters." He said it with the tone of a man who has just decided to resolve something quietly rather than publicly, which Sarah recognized as the tone of a man who has just understood that public may no longer be favorable to him. The room shifted, chairs moved. Uncle Don went immediately to the coffee station. Mark stood near the window and looked at his phone. Linda gathered her notebook and followed Thomas out into the hallway, pulling the door almost, but not quite closed behind them. It was during those 10 minutes that Dorothy Hayes stood up. She smoothed her coat with both hands first, a small automatic gesture, the kind a person makes when they are about to speak to someone important and want to look as though they had not been sitting in a corner chair for the past 35 minutes feeling like an afterthought. She crossed the room slowly and stopped beside Whitmore, who was rearranging papers at the far end of the table. "Excuse me," she said, "I am Dorothy Hayes. Eleanor Bennett was my closest friend. She mentioned I was included in her will, a small amount for some medical expenses I have been carrying. I was told the estate was still in process. That was 2.5 years ago." She paused. "I just wanted to ask, is there a timeline I should be aware of?" Whitmore looked up from his papers. He had the expression of a man performing patience. "Mrs. Pace." "Hayes," he said carefully. "Non-primary beneficiaries are handled through the executor's correspondence process after principal estate matters are finalized. Disbursements to secondary parties are currently pending under the estate's administrative hold." Dorothy's hands were still folded over her purse. "I take 4 medications," she said. "I stopped one of them in January. I could not afford it. It was $140 a month and I thought the estate would come through by spring." She stopped. "Eleanor knew about that. She mentioned it specifically. She told me she had taken care of it." "I understand," Whitmore said in the voice of a man who did not want to understand. "I would recommend directing any further questions to the executor's office in writing. We can provide the address." Across the room at the coffee station, Thomas had returned briefly for his cup. He was close enough to have heard every word. Sarah watched him pour the coffee, replace the carafe, and walk back toward the hallway door without looking in Dorothy's direction. Not with hostility, not with awareness. With the practiced absence of someone who has learned to be elsewhere whenever something inconvenient is making a sound. Dorothy Hayes nodded once, thanked Whitmore in the voice of a woman who has been thanked but not helped so many times that courtesy had become a reflex, and returned to her chair in the corner. Same mechanism, different name, same smile from behind a different desk. Sarah stood at the window on the far side of the room and ran the calculation. She had done this before, in federal cases where intervention meant exposure. The discipline was the same regardless of the room. Lay out exactly what you stand to lose, assign each item its actual weight, and then decide whether the decision you are about to make is the right one or simply the one that feels right. They were not always the same thing. Item 1 was the clock. Victor's filing was already in. But if Thomas's attorney filed the preliminary challenge before 4:30 in the afternoon and Sarah had already disrupted the proceedings, visibly already made herself the story instead of the evidence. Thomas could argue that the codicil submission was part of a coordinated personal attack rather than a legitimate legal action. Judges notice context. Context was not always on the right side. 1 hour and 49 minutes remaining. Item 2 was the 6 o'clock reading. She had planned to let the room hear the audit figures in the formal setting, in front of the Gazette reporter, in front of every relative who had spent 14 months accepting Thomas's version without asking a single question. If this became a hallway confrontation before then, Thomas controlled the opening narrative. And Thomas was very good at opening narratives. Item 3 was Lily's concert. 8 o'clock. 40 minutes by highway when the roads were clear. If proceedings extended, if an attorney filed motions, if a judge needed to be reached by phone, if anything became complicated in the way that things involving $847,000 had a tendency to become complicated, she might not make it. She had made a promise. Not to Lily, to Eleanor. Item 4 was 14 months of work, 4 months of forensic audit. $6,200 in retainer fees paid out of grocery money and a canceled school trip. The 47 pages. The 23 exhibits. The second accountant's written confirmation. All of it prepared with the specific intention of being used at the right moment, in the right sequence, for maximum legal clarity. She had not come this far to use her evidence as an emotional reaction. These were the things she would lose, in varying degrees, if she stood up from the window and walked across the room toward Dorothy Hayes right now. Is watching an injustice, one you have the standing to interrupt, one you have the knowledge to correct, One that costs you something real to address, ever simply watching? Or does stillness, at a certain point, become something that has a different name? Sarah's phone had 3 unread messages. She looked at the screen without opening them. Then she looked up at Dorothy Hayes. Dorothy was sitting with her purse in her lap again, her coat smoothed back down. After a moment, she reached into the left pocket of the coat, the one with the broken button, and took out a small square of folded paper. She unfolded it once, looked at whatever was written on it, and folded it closed again. She held it in both hands, not reading it, just holding it. Sarah could see, from across the room, that the handwriting on that paper was Eleanor's. She recognized it from 34 years of birthday cards and grocery lists pinned to the refrigerator, and notes slipped into her school bag on mornings when Eleanor had an early shift and could not say goodbye in person. The particular slant of the capital letters. The way Eleanor never fully closed her lowercase a. Whatever Eleanor had written to Dorothy, whatever promise she had committed to paper and given to this woman to carry for 2.5 years in a coat pocket with a broken button, was still there, still undelivered, still waiting. Sarah put her phone face down on the windowsill. She crossed the room. She did not explain why. She did not announce it. She simply moved, the way you move when a decision has already been made before your conscious mind has finished making it, and she sat down in the empty chair beside Dorothy Hayes, and she said, quietly, "Mrs. Hayes, my name is Sarah Bennett. Eleanor was my mother. Can I see what she wrote you?" From the window, Mark watched Sarah sit down. He knew what it meant. He did not need it explained. He had stood in this family long enough to understand exactly where a line was being drawn and what it would cost the person drawing it. He had watched Thomas shred documents once. On a Saturday, 8 months after the funeral, he had come by the house to drop off a casserole dish and found Thomas at the dining room table with a box of papers and a shredder. Thomas had said, "Just clearing out some old estate paperwork, nothing important." Mark had said, "Sure, no problem." He had driven home and not mentioned it to anyone. He told himself later that he had not known what the papers were. He told himself that it was not his place. He told himself that Thomas was the executor and probably knew what needed to be kept and what did not. He was aware, in the way that people are sometimes aware of things they have decided not to examine, that none of those things were the real reason. Now he watched his cousin sit down beside an old woman in a coat with a broken button, and he opened his mouth and he thought of 5 different things he might say, and he closed his mouth. And he looked back at his phone. His silence was a choice. He made it the same way he had made it 8 months ago. Quickly, quietly, without looking at what he was choosing. Thomas came back through the door at 2:41 in the afternoon. He stopped when he saw Sarah and Dorothy. Something moved across his face, fast, controlled, gone before it fully arrived. He crossed the room in 8 steps. Sarah. The patience was entirely gone now. Just the name carrying everything it needed to carry. This is not the time for individual conversations with guests. "Mrs. Hayes, we will be in touch through the estate correspondence process." "She has a note," Sarah said, "from Mom, written before she died." Thomas stopped. Eleanor wrote to her about the bequest, in her own handwriting, on a piece of paper Mrs. Hayes has been carrying for 2 years. Sarah looked at him. "I think that is relevant to the estate's record." Linda, in the doorway behind Thomas, looked at Dorothy Hayes for the first time since the meeting began. Thomas said, with the precision of a man snipping a wire. "I need to ask you to return to your seat," he said it to Sarah. 2:41 in the afternoon, 1 hour and 49 minutes until the window closed. Karen Holt arrived at 2:44 in the afternoon. She was Thomas's personal attorney, not the estate's. Sarah noted the distinction. Whitmore noted it too. She could see it in the way he shifted in his chair when Karen entered. Karen was 50, efficient, carrying a briefcase that she set on the table without asking permission. She shook Thomas's hand and did not shake anyone else's. Given the filing submitted this morning, Karen said to the room, as though she had been present for the past hour, "My client has asked me to formally note that the codicil's execution circumstances are under review. We will be requesting a 30-day extension of today's proceedings to allow for proper legal verification." 2:44 in the afternoon. Aunt Patricia said, "Oh goodness." Uncle Don unfolded his summary sheet and looked at it as though it might have changed. At the far end of the table, the younger of the 2 people who had come as witnesses to the formal reading, a woman in her 30s whom Sarah did not know, a colleague of Whitmore's apparently, had her phone in her hand beneath the table's edge. She was recording. Sarah registered this without reacting to it. A 30-day extension, Sarah said. On what grounds? Procedural verification of the codicil's notarization and witness credentials, Karen said. The notarization was performed by a licensed notary in Carver Falls County. The witnesses' signatures were verified by Victor Crane's office. All of this is in the filing. Sarah's voice was level. What specifically requires 30 days to verify? Karen looked at her with the particular expression of an attorney who has been asked a precise question she did not expect. We will be submitting a full statement of grounds in writing. Then I will look forward to reading it, Sarah said. In the meantime, the filing stands as submitted. The codicil's validity is a matter for the probate court to determine, and this reading should proceed on schedule. 2:47 in the afternoon. Thomas spoke to Whitmore in a low voice. Whitmore nodded once, slowly, the nod of a man who has just calculated which side of a situation he would prefer to be on when it resolved. He said, "Given the dispute that has arisen, I think it is appropriate to pause the formal reading until we have clarity on the codicil question." 2:51 in the afternoon. 1 hour and 39 minutes. The room had rearranged itself. Thomas and Karen were standing. Whitmore was seated but angled toward Thomas. Linda was at the door. The family, Patricia, Mark, Don, had formed a loose cluster near the coffee station that Sarah recognized as the physical language of people waiting to see who wins before they decide which direction they have always been facing. Dorothy Hayes remained in her corner chair. She had refolded Eleanor's note and put it back in her pocket. 2:53 in the afternoon. 3 messages arrived simultaneously. Sarah looked at the screen. The first was from Victor. Thomas's attorney just filed a preliminary challenge 8 minutes ago. Window still open until 4:30. Do not produce the audit yet. Let them build their case first. Hold position. Trust the sequence. The second was from a colleague at her federal office. Reporter from the Gazette called. Says Thomas's contact told her the reading is a private family matter and press may not be accommodated. She's asking if you have a comment. What do you want me to say? The third was from Lily. Mom, are you still coming tonight? Ms. Parker said it is okay if you are late, but please come. Sarah read all 3 messages. She did not reply to any of them. She placed her phone face down on the table. 2:56 in the afternoon. Karen Holt was on her own phone, speaking at full conversational volume, apparently not concerned about being heard. Yes, the situation is manageable. The filing looks like a personal grievance dressed up as a legal action. We should have a resolution well before 4. A pause. No, she does not have the original. She has copies. Sarah heard every word. She did not look up. She did not change her expression. She thought about a piece of paper folded into a coat pocket. Eleanor's handwriting. The particular slant of the capital letters. A woman who had stopped taking her medication in January because she thought the estate would come through by spring and it had not. And she had not told anyone because she did not want to be a burden to people who were grieving. She thought about a text message. Please come. When a person makes a promise to someone dying, to someone, forgotten to a child in a school auditorium who has learned that please is a word worth using. And keeping that promise requires stepping into a room that was not designed to admit her what is the actual cost of remaining still and who carries it? Not the person who chose stillness. They go home and sleep. 2:58 in the afternoon. 1 hour and 32 minutes. Sarah opened her laptop. She typed one message to Victor. Do not file anything else yet. I am ready when the room is. She closed the message window. She opened the audit document. 47 pages. 23 exhibits. The second accountant's verification on the final page read as follows. Findings are accurate. Documentation is thorough and replicable. She turned the screen slightly, not toward Thomas, not toward Karen, not toward anyone in the room, just toward herself. Just enough to see the first line of the executive summary clearly. Estate of Eleanor Ruth Bennett. Forensic review of fiduciary activity, years 1 through 6. Total irregular disbursements identified, $847,000. Confidence level, high. She had not come 14 months and $6,200 and 1 canceled school trip to use this as a reaction. She had come to use it as a conclusion. The difference mattered. She waited. Karen Holt made her error at 3:06 in the afternoon. She had been speaking to Whitmore for several minutes in the careful language of attorneys who believe they are the smartest people in a room. She said, "The original filing appears to lack proper standing given the executor's established authority. The codicil, if it exists in legally executable form, would need to clear a verification process that our office estimates at approximately 30 days minimum. In the meantime, the estate's current administrative structure remains in effect, and no disbursements should be processed under any alternative authorization." She said, "If it exists." Sarah set her coffee cup down. She turned her laptop to face the center of the table. She did not say anything first. She did not announce what she was about to do. She simply opened the document that had been sitting in the center of her screen since 2:33 in the afternoon and turned the machine so that the text was visible to everyone seated within reading distance, and she waited. The room oriented toward the screen the way rooms do when something changes without warning. "The first document," Sarah said, "is the codicil to Eleanor Ruth Bennett's last will and testament. Executed October 14th in Carver Falls, Ohio. Notarized by Rebecca Odom, Notary Public, State of Ohio. Witnessed by Gerald Crane and Diane Moorfield, both Ohio residents whose contact information is in the first exhibit." She paused. "The probate court reference number is in the header. Filed this morning at 9:47 in the morning." Thomas had not moved. "The operative clause," Sarah continued, her voice the same register it had been, "all afternoon, level, precise, carrying no more and no less than the words required, reads as follows. In the event of documented evidence of fiduciary breach by the primary executor, this codicil appoints Sarah Louise Bennett as co-executor of the estate with override authority, effective immediately upon submission of supporting documentation to the probate court of jurisdiction." She stopped. She looked at Thomas. She waited for the full weight of what she had just read to arrive. It took approximately 4 seconds. "What that means, Thomas," she said, "is that as of 9:47 this morning, every unilateral decision you have made as sole executor is now subject to my review and, where applicable, reversal. The disbursements you have authorized. The expenses you have categorized. The filings your attorney submitted 42 minutes ago. All of it now sits within the scope of co-executor oversight." She looked at Karen Holt. "The 30-day extension your client requested is not within his authority to request without my co-authorization. You may want to note that." Karen Holt said nothing. She wrote something on her legal pad. "The second document," Sarah said, "is a forensic audit of the estate's financial activity over the past 6 years. Prepared by me and independently verified by Eleanor Walsh, a certified public accountant with 22 years of forensic practice. It is 47 pages. I am not going to read all of it. I am going to read the summary." She scrolled. "Total assets under management during the audit period, approximately $1.4 million, inclusive of the Clement Street property, liquid savings, and investment accounts." She looked up briefly, then back at the screen. "Total documented irregular disbursements, $847,000, across 23 separate transactions, under expense categories that do not correspond to any recognized standard in estate accounting practice." Aunt Patricia made a sound. Not a word, just a sound. "Exhibit 7, Sarah said. March of year 2. A charge of $34,000 against the estate, categorized as structural maintenance, Clement Street property. I cross-referenced this against the city's permit database, the building's maintenance log, and the contractor registry for Carver Falls County. No work order on file, no permit pulled. No contractor by the listed vendor name registered in the county for that period or any surrounding period." She paused. "The entry is in the estate's accounting software. It is not in any other record that exists." She scrolled again. "A legitimate 4-unit residential property of Clement Street's age and construction type, in this county, averages between $8,000 and $12,000 in annual maintenance costs. Over 6 years, that is a maximum of $72,000. The estate records show $341,000 in maintenance category expenses over the same 6 years." She let that number sit. "The gap is $269,000 in one expense category alone." The room was very still. "I want to be precise about what this audit establishes and what it does not," Sarah said. "It establishes a pattern, 23 transactions, 6 years. A consistent methodology. Money leaving the estate through channels that produce no corroborating documentation. She looked at Thomas directly. This is not about today, Thomas. Today is simply the day someone was in this room with the data and the legal authority to say it out loud. Thomas's voice, when it came, was controlled but thin at the edges. You manipulated the discovery process. You had your attorney file requests specifically designed to. I submitted a standard beneficiary records request to the probate court, Sarah said. The court granted it over your attorney's objection, which is in the record. I then engaged a licensed forensic accountant and a second one for independent verification. When both reached the same conclusions, I brought the findings to Victor Crane. That is the complete sequence. She looked at him without expression. The 23 transactions were your choices. The missing invoices were your choices. The $847,000 was your choice. I did not create any of that. I found it. Karen Holt had her phone out. She was typing. Sarah turned to Mark. He had been standing very still near the window since the audit summary began, holding his phone in a way that suggested he had forgotten he was holding it. Mark, Sarah said, I need you to contact the Carver Falls County Recorder's Office and request copies of every permit filed for work at the Clement Street address over the past 6 years. You know the address. Please do that now. She said it the way you assign a task at a staff meeting. No indictment in it, no mercy either, just work that needed to happen. Mark looked at her. Something in his face shifted, not relief, not absolution, recognition. The look of a person who has been waiting, without knowing it, to be told what to do after a long period of choosing not to do anything. He unlocked his phone. Then Sarah turned to the corner of the room. Dorothy Hayes had not moved from her chair since the meeting began. She sat with her purse in her lap and her coat with its broken button, watching Sarah the way a person watches something they have stopped allowing themselves to hope for. Sarah called Victor Crane. She put the phone on speaker and set it on the table. He answered on the second ring. Victor, Sarah said, I need you to initiate the secondary beneficiary disbursement for Dorothy Hayes, $12,000, Eleanor Bennett's estate. I am authorizing it now as co-executor under the codicil. Confirmed, Victor said. I will have the transfer initiated within the hour. End of business today. Thank you. Sarah ended the call. She looked at Dorothy. It will be in your account by 5 o'clock, she said. Dorothy Hayes looked back at her. Her hands were still. Her expression was not the expression of someone receiving good news. It was the expression of someone who had been carrying something heavy for a very long time and had just been told they could set it down. She reached into her coat pocket. She took out the folded piece of paper. She looked at it for a moment, then she looked at Sarah and said, quietly and without any performance in it, Eleanor told me you would know what to do. She said it the last time I saw her. She said Sarah will know. She folded the note closed and put it back. Sarah nodded once. Then she turned back to Thomas. He was still standing at the head of the table. The presentation was still on the screen behind him, the Clement Street property valuation, the number that had meant one thing an hour ago and meant something else entirely now. He had not closed it. He had not moved toward it. He was standing in front of it in his gray jacket with the expression of a man watching a structure he had built carefully over 6 years absorb the consequences of what it was built to do. Fairness is not just a moral principle, Thomas, Sarah said. In estate law, in fiduciary practice, in every field where one person is authorized to manage assets that belong to someone else, it is a legal obligation with enforceable consequences. Institutions that fulfill that obligation, people who fulfill it, tend to be protected by the law. Those who rely on assumed authority and the silence of people who are paying attention tend to end up in the court record. She picked up her laptop. She closed it. She looked at her phone. 3:24 in the afternoon, 1 hour and 6 minutes until the window closed. She looked at Karen Holt. Submit whatever motions you need to submit. The court will address them in light of what was filed this morning. The sequence is already in motion. She picked up her bag. The room did not erupt. That was the thing about the truth when it arrived in the form of a 47-page document with a second accountant's signature on the verification page. It did not arrive loudly. It arrived the way a structural diagnosis arrives. With numbers, with dates, with the particular quiet of something that has been true for a long time finally being said in a room large enough to hold it. Thomas sat down. He did it slowly, the way a person sits when their legs have made a decision before their mind has. He looked at the presentation screen. The slide was still showing the Clement Street property valuation, the figure he had prepared, the framing he had chosen, the narrative he had rehearsed. He did not close the presentation. He looked at the number for a long time and appeared to be doing arithmetic that was not coming out correctly. Karen Holt walked to the far end of the room and made a phone call in a voice too low to hear. When she came back, she sat beside Thomas and opened her laptop. She did not look at him. The specific quality of her not looking told Sarah everything she needed to know about how that phone call had gone. Whitmore closed his own laptop quietly. He picked up his legal pad and wrote 4 lines in neat cursive, then set the pen down parallel to the pad's edge, the way someone does when they want the object to look deliberate. He did not show anyone what he had written. He would review it again when he was alone. He had been Whitmore and Associates for 21 years, and he understood that some afternoons required him to think carefully about what he had agreed to be part of and how much of it was still recoverable. Aunt Patricia had stopped nodding. She was looking at her hands in her lap with the focused attention of a woman examining something she had believed in for a long time and was now seeing from a different angle. She opened her mouth once, then she closed it. She would call Sarah in 3 weeks on a Sunday afternoon, and it would be the most difficult call she had ever made, and she would begin it with, "I did not ask," and Sarah would say, "I know," and that would be where they would start. Mark stood slightly apart from everyone, his phone to his ear, speaking to someone at the county recorder's office in a voice lower than usual. He gave the Clement Street address without hesitation. He had been to that property twice, once to help Thomas check on a maintenance issue, once to help Thomas take photographs of what Thomas described as storm damage. He was reconstructing those visits now, looking at them from the angle the audit had just provided. His thumb trembled slightly while he wrote down the reference number the recorder's office gave him. He wrote it down carefully. He would do this correctly. It would not make up for the Saturday with the shredder, and he understood that now, and the understanding would stay with him in a way that mornings, for a while, would carry. Uncle Don had his folded summary sheet out again. He was reading it for what appeared to be the 3rd time. His mouth was slightly open. He was the kind of man who could hear the same information twice and not understand it, but understand it completely when read alongside the words, $891,000 and 23 transactions and no permit on file. He was doing that understanding now, slowly, in the way of a man for whom things tended to arrive a little after everyone else. Linda had closed her leather-bound notebook. She had been the one person in the room who understood, from the moment Sarah said the word codicil, exactly how this afternoon was going to end. She had known because she had seen the files. She had been present for conversations she had participated in, and would now need to carefully reconstruct in terms of what she had known and when. She looked at the closed notebook in her hands and did not open it again. The woman from Whitmore's office, the one who had been recording beneath the table, lowered her phone and held it in her lap. She looked at the screen. She looked at Thomas. She looked at the door. She thought about what the video contained and what its existence meant and what she was going to do with it. She made a decision. She locked her phone and placed it in her bag and sat very still for the remainder of the meeting. Dorothy Hayes stood up when Sarah walked past her chair. She did not say anything elaborate. She reached out and briefly held Sarah's wrist, not stopping her, just contact, just a moment, and then she let go. She said she would be proud. Sarah looked at her. She already was, she said. She was proud of you for carrying that note for 2.5 years and still showing up. Dorothy looked down at her coat pocket. She nodded once, slowly. The nod of a woman settling something inside herself. Sarah walked to the door. She did not look at Thomas. She did not look at the presentation screen or at Karen Holt's laptop or at the legal pad on the table or at any of the things in the room that still needed to be addressed. Because they did not need to be addressed by her, not today, not in this room. The court record would address them. The audit would address them. The codicil would address them. Victor Crane would address them. She had done what Eleanor's note said to do. In the hallway, she took out her phone. One ring. "Mom, I am on my way," Sarah said. She pushed through the building's front door into the October air. It was cold and sharp and smelled like leaves and distance, and the particular clarity that comes after something long held has finally been said. 3:31 in the afternoon. 59 minutes until 4:30. 47 minutes to Lily's school. She walked to her car and did not look back at the building. 3 months later. Mark Calloway volunteered for the estate's document reconciliation work in November. No one asked him. He simply called Victor Crane's office on a Monday morning and said he wanted to help with whatever needed cataloging, and Victor, who understood people well enough to know when an offer was also an act of accounting, said yes. He spent 11 Saturdays going through the physical estate files, the ones stored in boxes at Whitmore's office, the ones at Clement Street's management office, the ones Eleanor had kept in a filing cabinet in her hallway that had passed to Thomas after her death and were now with the court's order being returned to the estate's formal record. He was methodical. He cross-referenced everything against the digital records Sarah had obtained through discovery. He found 2 transactions that Sarah's audit had not caught a charge of $19,000 in year 3 and a charge of $25,000 in year 5, and he reported both to Victor immediately in writing, with the source documents attached. The total, with those 2 additions, became $891,000. He created a new documentation protocol for estate correspondence, every communication to be copied simultaneously to both co-executors, with a time-stamped receipt required before any action could be taken. Victor incorporated it into the estate's management agreement. Mark still has difficulty on Saturday mornings. Not insomnia exactly, just an early waking, a few minutes of lying still in the gray light before the day begins, during which he thinks about a dining room table and a box of papers and a shredder. And the word sure that he said when he should have said something else. He goes to Clement Street sometimes. The building looks better now, the deferred maintenance addressed, the exterior repainted the color Eleanor originally chose. He drives past it. He does not usually stop. The weight does not lift. He has stopped expecting it to. He carries it the way you carry something when you understand that carrying it carefully is the closest thing to making it right. The referral to the Carver Falls County District Attorney's Office took 3 weeks to process. The investigation that followed took 11 more. These things do not move quickly, and they should not. The machinery of accountability, when it functions correctly, is slow and procedural and requires a standard of evidence that takes time to assemble properly. During those 11 weeks, Karen Holt withdrew as Thomas's attorney in week 4. He retained a public defender who specialized in financial crimes. The investigation, drawing on Sarah's 47-page audit as its foundation, identified the 2 additional transactions Mark had found and re-examined every estate disbursement going back to the month Thomas assumed executor authority. The final count was 25 transactions. $891,000. Thomas entered a plea agreement in January. Full restitution to be recovered through liens placed against his personal assets, including his own property and retirement accounts, to be paid over a period not to exceed 7 years. 3 years of probation. Permanent disqualification from serving as executor or trustee of any estate in the state of Ohio. Mandatory completion of a fiduciary ethics program. No imprisonment because the system moved at the pace it moves and arrived at the outcome it arrived at. And it was imperfect and slow, and it was still more than had existed before Sarah turned a laptop screen around at 3:06 in the afternoon on a Tuesday in October. The Clement Street tenants received written notices in December. Maintenance that had been billed against the estate and never performed, 14 items documented in Sarah's audit, was completed within 60 days. 3 tenants who had filed informal written complaints over the years received apologies and rent credits totaling $8,400. Whitmore and Associates implemented a new dual authorization policy for all estate disbursements above $5,000 in cases where they serve as estate counsel. It was not announced publicly. It was simply added to the firm's standard operating procedures, quietly, in the way that institutions sometimes change when they understand that the alternative is being the subject of the next set of exhibits. Dorothy restarted her medication in the first week of November, a Tuesday morning, with a glass of water and the quiet satisfaction of someone restoring something that should never have been interrupted. She used part of Eleanor's $12,000 for that and for the heating bill that had accumulated over a particularly cold October and for the coat button, which a tailor on Granger Street replaced for $6 while she waited. She still visits Clement Street on Sunday afternoons sometimes, not every week, just when the weather is good and she feels like walking past the building that Eleanor talked about for 30 years with the particular pride of a woman who had built something lasting out of Saturday work and careful decisions. One Sunday in December, she met Marcus Webb, the property manager Sarah had hired, a man with 14 years of experience and a clipboard and the unhurried efficiency of someone who actually liked buildings. He asked if she knew the original owner. Dorothy told him about Eleanor for 2 hours, standing on the sidewalk in her repaired coat. She told him about the Saturday house cleaning jobs and the 34 years of teaching in the green ledger book Eleanor kept on the kitchen shelf. Marcus listened to all of it. Before Dorothy left, he said, "She sounds like the kind of person who built something to last." Dorothy said, "She did, she just needed the right person to protect it." The estate's annual operating costs in Thomas's final year of sole management were $341,000 across maintenance, administrative fees, and management overhead. The estate's annual operating costs in its first year under co-executor oversight were $67,000, within the documented legitimate range for a property of Clement Street's type, age, and size. The difference was $274,000. Returned effectively to the estate, to Eleanor's intent. 14 deferred maintenance items completed within 60 days. 3 tenants made whole. The net value of the estate, recalculated after the restitution order, was increased by $891,000 on paper money that had been removed, now formally owed back. Now moving through the lien process toward the accounts where it belonged. The woman from Whitmore's office, her name was Claire Donovan, a paralegal who had been with the firm for 2 years, posted 3 minutes and 47 seconds of footage on a Tuesday evening. The video began with Thomas saying if it exists in legally executable form and ended with Sarah closing her laptop. It reached 2.3 million views in 11 days. The Ohio State Bar Association issued a statement on executor fiduciary responsibilities within 3 weeks. A state senator introduced a bill in January requiring mandatory independent audits for estates exceeding $500,000, where a sole executor has managed funds for more than 3 years without beneficiary review. The bill was still in committee at the time of this telling. These things move slowly. That is the nature of things. Victor Crane's office received inquiries from 6 families in Ohio within 2 months, each describing variations of the same pattern, a sole executor, a standard administrative hold, and years of being told the estate was still being processed. He took 4 of those cases. Sarah hired Marcus Webb in November, negotiated his contract on a Wednesday afternoon, and was back at her desk at the Federal Bureau of Financial Investigation by Thursday morning, reading a case file that involved a different kind of document and a different kind of erasure. She got to Lily's concert at 7:53 in the evening, 7 minutes late. She slipped into the back row of the school auditorium while the second piece was still playing. Lily saw her from the stage, a flicker of recognition across the face of a 9-year-old who had learned to watch for her mother in the back of rooms. That was enough. That had always been enough. The thing Sarah kept from that afternoon in October was not the audit figures, which she knew by memory. It was not Thomas's expression when the legal meaning of the codicil arrived fully in his understanding. It was not even Dorothy's note, though she thought of Eleanor's handwriting often, the particular slant of it, the capital letters. What she kept was a question. Eleanor had gone to Victor Crane's office 9 months before she died. She had written the codicil, named Sarah as co-executor, and left instructions to hold the document until the right moment. She had not told Sarah any of this while she was alive. She had simply trusted that the moment would come and that Sarah would be ready for it. How did she know I would be ready? Sarah did not have an answer. She was not certain she was supposed to. Something real happened in a conference room in Carver Falls, Ohio, on a Tuesday in October. 23 transactions, 25 by the time the investigation was complete, were documented, examined, and entered into the public record of a probate court. An old woman restarted medication she had been unable to afford. A building received 14 repairs that had been billed for and never performed. A court issued an order requiring money to return to the place it had been taken from. These things happened. The system, at the end of a long and imperfect process, produced something that resembled accountability. That is worth saying. Without qualification, it is not nothing. But it requires honesty to say what else it proves. Sarah won because she had 14 years of federal forensic training and the specific vocabulary to read 847 pages of estate records and identify, with precision, what was absent. She won because she could afford $6,200 in legal retainer fees, stretched across 3 months of rice and beans and a canceled field trip. She won because her mother understood, 9 months before she died, that a verbal promise is not a legal instrument, and spent an afternoon in an attorney's office creating one that was. She won, in other words, because she had a codicil, because she had independent verification, because she had Victor Crane, because she had been trained, professionally and personally, to believe that documentation was not paranoia, it was preparation. What about the person whose mother did not know to leave a codicil? What about the beneficiary who never studied accounting, who cannot read a fiduciary audit, who does not have a federal colleague to recommend a probate attorney? What about the family that sits in a conference room and nods at a presentation because they do not have the language to ask the question that stops the room? What about the Dorothys, the people waiting for a disbursement that has been processing for 2.5 years, who do not happen to know someone who does? How many estates are currently managed by someone who is counting on the beneficiaries not knowing what to look for? How many times does a sole executor say standard administrative hold to a room full of people who have no reason to know that phrase is not in any legal handbook? How many systems in estate law, in banking, in healthcare, in every institution where one person is trusted to act on behalf of another, change only when someone who already has the tools to fight happens to be the one who was wronged? And what does it say about the stories we choose to tell that the ones we return to most often are the ones that end with a laptop open at the right moment and a codicil already filed? And enough preparation to walk out of the room intact? What does it say that the 10,000 stories that end in silence in a folder misfiled in a bequest, never processed in a family that did not know they could ask? Those stories mostly do not make it to the room where anyone is listening. Eleanor Bennett was a middle school math teacher who worked 2 jobs and kept a green ledger book on the kitchen shelf and understood, before most people articulate it, that knowledge is not neutral, that knowing how to find a 1967 survey in a county records office is not a universal skill, that the question underneath every document, every receipt, every carefully maintained file is not just what does this prove, but who gets to know how to prove it. That is the question Sarah carries. Not the $891,000, not Thomas's face at the table, not even Dorothy's note in its pocket. The question was this: what do you do with what you know? And who else deserves to know it? She does not have an answer yet. She is working on it. At Revenge Files St. 03, we do not soften the emotion or dilute the message. We tell powerful fictional stories inspired by real-world issues that too many people face in silence, in estate disputes, in family courtrooms, in conference rooms where someone is counting on no one asking the right question. If today's story moved you, if it made you think, made you feel, or made you see something in your own life from a different angle, share your thoughts in the comments below. And subscribe so you do not miss the next story. Because the conversation does not end here, it is just beginning. This is a fictional story inspired by real systemic issues documented in public research on estate mismanagement, fiduciary fraud, and inheritance disputes. All characters, institutions, and events are entirely invented. Any resemblance to real persons or organizations is coincidental.